Good morning. Today I'm going to be talking to you about antitrust law in healthcare. Antitrust law in healthcare is exceedingly important and will continue to be incredibly important going forward. And that's primarily due to the industry shifting towards more consolidation to gain efficiencies through economies of scale, but also more power in negotiations. The antitrust laws in the United States are primarily enforced by the Department of Justice and the Federal Trade Commission. There also is significant antitrust laws at the state levels that are enforced by the attorneys general of the respective states. The Department of Justice has the following quote on the Antitrust Division's main page, and it says, and I quote, "Competition in the healthcare industry benefits consumers because it helps contain costs, improve quality, expand choice, and encourage innovation. The Antitrust Division enforces the antitrust laws in healthcare to protect competition and to prevent anti-competitive conduct." The Federal Trade Commission similarly has the following quote on their main page. "When healthcare markets are competitive, consumers benefit from lower costs, better care, and more innovation." Some relevant laws and regulations pertaining to antitrust are, and this is probably the most notable and recognizable, the Sherman Antitrust Act, which focuses on restraints of trade and monopolies. The Sherman Antitrust Act really has several main focuses, but I would say the most notable four main focuses are market power, price fixing, market divisions, and monopoly power. The Clayton Act, which was enacted a couple decades after the Sherman Act, was really intended to strengthen the Sherman Act. And it contains everything the Sherman Act contains, but additional strengthened language around price discrimination, sales that are conditioned on the buyer not dealing with the seller's competition, and mergers and acquisitions that will substantially lessen competition. Many of you probably recall the Herfindahl-Hirschman Index. This is a tool that really measures market concentration and is used heavily by the Department of Justice when evaluating whether a merger or acquisition will lead to a monopoly or some of the impacts that are created by monopolies. The Federal Trade Commission Act is intended to address unfair methods of competition and commerce. And finally, the Robinson-Patman Act is an anti-price discrimination act intended to protect smaller businesses from being harmed or even going out of business by larger businesses through the discrimination in prices, promotions, and advertising. This is often referred to as predatory pricing. One thing that's very important to note and will become relevant when I discuss a prominent case in the state of California, the state of California v. Sutter Health, is the potential for trebling of damages. And essentially what that means, and this is relevant for the Sherman Act, the Clayton Act, and then the Cartwright Act, which is a California state piece of legislation around antitrust. And essentially that states that damages, monetary damages that are awarded in civil cases can be tripled. So that's very important, and it plays a significant role in the motivation of organizations to settle out of court. Some relevant cases that are pertaining to antitrust are the U.S. versus Geisinger Health and Evangelical Community Hospital. This case this suit was brought in 2020, and essentially it alleges two complaints. One is a violation of Section 1 of the Sherman Act, and the other complaint is a violation of Section 7 of the Clayton Act. In short, Geisinger acquired 30% interest of Evangelical Hospital in exchange for a $100 million pledge for investments in projects and intellectual property. Essentially, the U.S. government was concerned with this because they felt like it would deter competition between the two organizations and thus damage the care delivery for the residents of that community. Another relevant case is the U.S. versus CVS Healthcare and Aetna. And essentially, this alleges that the merger of CVS and Aetna would substantially lessen competition pertaining to the sale of individual prescription drug plans. To mediate this, the resolution required that Aetna was to divest all of their prescription drug plan business, which they did, and they actually sold that off to WellCare in 2018. And then one more that I think is interesting is Seaman versus Duke University. And essentially, this case was a suit brought against Duke, University of North Carolina, and other like organizations that alleged that these organizations had a quote-unquote no poach policy in place pertaining to their medical staff. And part of the settlement for this was that Duke and other organizations named in the suit were precluded from engaging in any sort of anti-competitive agreements similar to this in the future. They also had to engage in substantial training for their organizations to avoid similar cases like this in the future. So the impact of antitrust law on healthcare, I had mentioned this briefly earlier, is healthcare is moving towards consolidation and integrated networks, and this is really to gain economies of scale and contracting power. So the DOJ has taken this very seriously. They filed 7 suits since 2019, and the FTC has filed 20 suits since 2020 alone. In the future, this will continue to be incredibly impactful as the market is only going to move further in this direction. Healthcare is incredibly expensive, and organizations are really needing to find every advantage that they can to reduce costs and stay competitive. So finally, I'd like to discuss an antitrust case against Sutter Health, and this was brought by the state of California in 2018. And what this case alleged was that Sutter Health, due to their size and market dominance, was engaging in unfair practices as it relates to contracting. Some of the things that were alleged is Sutter Health was engaging in contracts and really forcing insurers to cover like services at other Sutter Health hospitals that were outside of network. That was one. And 2 was really Sutter Health was through price secrecy policies enacted, was charging exceedingly expensive rates to their payers. And this was highlighted by Attorney General Javier Becerra when he was still Attorney General of California. There was a 60 Minutes expose on this, and there's been a lot of notoriety around this. And ultimately, Sutter Health agreed to settle out of court. The primary reason why Sutter Health settled out of court was due to the potential of trebling impacts from the monetary findings. And so Sutter Health agreed to pay $575 million in monetary damages, and they agreed to enact changes in contracting practices to really preclude from further activity that is deemed anti-competitive in nature. The Attorney General agreed to this, and it actually in March 2021 received its preliminary approval through the courts in California. So it still does need final approval, but this is a very important step. One thing that is very important to note with this settlement, Sutter Health was able to maintain its integrated network and was not forced to break up. That is my presentation on antitrust law in the the United States pertaining to healthcare. As I mentioned, antitrust law is incredibly important and will continue to be of great focus well into the future. I have an accompanying PowerPoint with cited sources that I will be submitting in addition to this video. Thank you for your time. Have a great week.